lead the prayer first.
If everyone will join me, in the name of the Father, and the Son, and the Holy Spirit. Lord, bless us this time, 1 week before Christmas, and remembering the needs of our island, and remembering the priorities of our people, and helping us to work collaboratively as a group of representatives of our populace to make the best decisions for our land, for our people, and for our future. In your name, amen. In the name of the Father, and the Son, and the Holy Spirit.
Senator Tenorio, can you please again move to today's agenda, December 18th, 2007?
Mr. Speaker, I move that the agenda for today be adopted.
And if there's no objection, Senator Tenorio, would you care to, well, let's kind of spread the wealth here. Senator Pangilinan, would you care to lead the Guam hymn? I'm ready. Senator Lujan, if you can please lead the national anthem. Roll call.
Senator Bloss. Speaker Calvo.
Present.
Senator Espadon. Here. Speaker Forbes. Senator Guthertz. Senator Ishizaki. Senator Lujan. Senator Munya Barnes. Senator Palacios. Speaker Pangilinan. Senator Respicio. Senator Shimizu. Senator Shimizu. Senator Tenorio. Senator Wampet. Mr. Speaker, I wish to report there is a quorum.
Okay, Thank you, Madam Clerk. Senator Tenorio, and call for the approval of the Legislative Journal.
Mr. Speaker, I move that legislative journals dated October 22nd, 2007 and October 26, 2007, as well as December 14, 2007 be approved.
No objections to order. Senator Tenorio on communications and petitions.
Mr. Speaker, there are communications and petitions. I move that they be considered to have been read and appended to today's legislative journal.
And no objections to ordered. Senator Tenorio, reports of standing committee, messages from the governor.
Mr. Speaker, I move that the messages of the governor be considered to have been read as well and also be appended to today's legislative proceedings.
Okay, so ordered. Reports on standing committees and reports to
Speaker.
select committees.
Mr. Speaker, I move that the reports of standing committees be considered to have been read and also appended to today's journal.
Okay, I have no objections, so ordered. Senator Tenorio on the introduction of first reading of bills and resolutions.
Mr. Speaker, I move that Bill number 198 EC to Bill number 199 EC be considered to have been introduced and first read and receive the first reading.
Okay, and so ordered. We're in motions.
Mr. Speaker, I move that Speaker Forbes be excused from today's proceedings.
Okay, and if there's no objection, so ordered. Okay, Senator Tenorio on motions.
Mr. Speaker, I move that all legislative certificates, resolutions of commendatory, congratulatory, condolence nature be approved by the body, and that all names of the members be added and appended to the list of sponsors, and further that the legislative council be authorized to make such necessary technical corrections.
And if no objection, so ordered. We are still in motions. Senator Pangilinan.
Thank you very much, Mr. Speaker. Mr. Speaker, I'd like to move to amend the agenda to place Bill number 137 EC at the bottom of the second reading file. It's a bill relative to government travel. The committee reports have been filed with 4 votes to pass, 3 votes to report out, and has been filed with a clerk, and I have copies for all the members here.
Okay. And if there's no objection, so ordered. Senator Wanpat. Well, we are still in motions.
Thank you, Mr. Speaker. Mr. Speaker, I'd like to make a motion to place resolutions 95 and 96 on the...
I'm sorry, Senator Wanpat, I didn't quite...
Resolutions, I'd like to place resolutions 95 and 96 on the agenda. One has to do with Agent Orange, and the other is for the Guam Congress building for renovation.
Okay, and if there's no objection, so moved. Senator Shimizu.
Thank you, Mr. Speaker. What I want to do is see if I'm in order. I'd like to make a motion for the body to vote on our legal counsel. It's an attaché, all attachés. I mean, I want to find out. I mean, I see the last time we had a
Sure.
legal counsel that resigned, and then we had another. I'm back here, and if the body is going to nominate a legal counsel as an attaché, it must be voted according to the standing rules, and I just wanted to bring that up. According to the standing rules, the legal counsel is an attaché who have to be sworn in accordance to our standing rules. So like I said, I wanted to do a power check with you, Mr. Speaker, if I'm in order. If not, I think it would, if indeed Mr. Ray Souza is the nominee to be the attaché as the legal counsel of the legislature, I think it would be right and proper that he gets the full vote and confidence of the members of the body.
Yeah. Thank you very much, Senator Shimizu. Senator Shimizu, again, when we had the resignation of Attorney Highsmith as legislative legal counsel, I did do a thorough review of the standing rules in regards to the filling of vacancies and a permanent vacancy such as this. And I will quote on the standing rules, and this is Rule 3 in regards to vacancies. permanent vacancies. And in Section 3-01, in case of a permanent vacancy in the office of the Speaker, such vacancy shall be filled for the unexpired term of office from among the other members of the Legislature in Guam by election by a majority vote of the members. If such a vote shall result in a tie, the Vice Speaker shall continue to assume the duties of the Speaker until such time as a new Speaker is elected. And I want to put emphasis on the next language, provisions in the standing rules. If a permanent vacancy occurs in any other office or legislature in Guam, including the offices of Vice Speaker, Secretary of the Legislature, Parliamentarian, Senior Senator, Standing Committee Chairperson, or Attaché, such vacancy shall be filled by appointment by the Speaker. Any vacancy not a temporary vacancy is a permanent vacancy.
Right.
So based on the standing rules, I have made an appointment as my position as acting Speaker. Now, there can be...
I'm
Now,
not
there can be
talking
a
about the
first-
Speaker. I just want to show the vote of confidence because it keeps changing. When I came here, I didn't know
Yes.
that the legal counsel was an attaché, had resigned. I didn't get that information, and I met Mr. Ray Sosa. So
Yeah.
he's an attaché, he's an officer, and if he hasn't sworn in to that, and I just want to make sure to say that he has my vote of confidence. And I was looking at the standing rules, and I didn't go further. And that's why I call it a power check, because I wanted to understand that. Because if there is an appointment of such, then I don't know if I received that as the attaché legal counsel. And so if that has already been done, I'm happy to hear that, because I want to make sure that next week it's not another face. You know?
Thank you.
And if you are an attaché, I think that's you hold a very special distinction, just like we have in terms of the sergeant at arms and all the others. And I think I wanted to just give my sense on that power check. If it's enough for just the Speaker, Mr. Speaker, the Speaker's choice is good for me. And if we had to vote, I would. And have you raised your taking the oath of office? No, because I think all attachés are required, I think. Again, a second part check. If not, you can deal with that, because the standing rules does show that the attachés all took their oath of office to the attachés. And if that's not been done, Mr. Speaker, then it might be in front of the body that he would do so. Ray, congratulations to you. Thank you, Mr. Speaker.
Okay, and actually, that's a very good question there, Senator. Again, based on the provisions of the standing rules, I have made the appointment. But if there is an order for an oath, then that shall occur. So if I could call, please, the Sergeant at Arms. We're going to take a 2-minute recess. Raise your right hand and repeat after me. I solemnly swear in the presence of Almighty God that I will well and faithfully support the Constitution of the United States, the laws of the United States applicable to Guam, and the laws of Guam, and that I will conscientiously and impartially discharge my duties as a member of the 25 in the Saturn Guam. So, congratulations. Give him a hand. We are still in motions. Okay. And if there, Senator Tenorio. Okay, we'll move forward. If we're out of motions. Leave the legislative. Senator Tenorio.
Mr. Speaker, I move that Bill number 119EC be placed in third reading. I'd like to briefly comment on it. I'm sorry.
We're still in motions, so is that for
I thought you were
motions?
finished with motions.
No, but if there's no motions, no motions?
Well,
If there are no other motions,
I thought you said we're out of motions, so.
if there are no other motions, Senator Tenorio, we're through with motions. Senator Tenorio? Second reading?
All right. So, Mr. Speaker, thank you. I move that Bill number 119EC be placed in third reading. I'd like to speak briefly on the motion.
Senator, we're still in legislative concurrence? Not yet. No, we're in legislative concurrence? Let's move on to legislative
All right.
concurrences, Senator
Okay.
Tenorio. Why don't we do it,
Yeah. So on the motion, Mr. Speaker, I move that from the Committee on Finance, Taxation, Commerce, and Economic Development on the appointment of Mr. June Lin to serve as the member of the Guam Real Estate Commission be placed in the voting file with a recommendation to do confirm.
and if there's no objection, so ordered. Oh,
Speaker, I
Senator,
also-
oh, I'm sorry. Senator Palacios on the motions for the moving into the third reading and voting file for the appointment of Mr. June Lin to the Guam Real Estate Commission. Do you have an objection?
Okay.
No objection? So ordered. Senator Tenorio?
Mr. Speaker, from the same committee, I also move that Ms. Elizabeth C. Duenas also be placed in third reading, her nomination to serve in the same commission, Guam Real Estate Commission, with a recommendation to do confirm.
And if there's no objection, so moved, so ordered.
And moving
Senator
to the
Tenorio?
next item, Mr. Speaker, I move also that the nomination of Mr. Arnold C. Jose to serve on the Guam Economic Development and Commerce Authority Board of Directors also be placed in third reading with a recommendation to do confirm.
And if no objection, so ordered.
On item 4, Mr. Speaker, I also move from the same committee that the appointment of Ms. Belinda S.R. Magat to serve as a member of the Alcoholic Beverage Control Board be placed in third reading with a recommendation to do confirm.
And if there's no objection, so ordered.
Mr. Speaker, I also move from the Committee on Tourism, Maritime, Military, Veterans, and Foreign Affairs on the appointment of Mr. Joseph F. Camacho to serve as a member of the Board of Directors, Jose D. Leon Guerrero Commercial Port, with a recommendation to do confirm, also be placed in the third reading file.
And if no objection, so ordered.
Mr.
Senator
Speaker, Mr. Speaker, I also move that the appointment of the Honorable Catherine A. Merriman to serve as Associate Justice of the Guam Supreme Court with a recommendation to report out be placed in the voting file.
And if there's no objection, so ordered.
Mr. Speaker, I move from the Committee on Health, Human Services, and Homeland Security on the appointment of Ms. Lou Leon Guerrero to serve as the member of the Guam Memorial Hospital Authority Board of Trustees be placed in the third reading file, the voting file, to with a recommendation to do confirm.
And there's no objection, so ordered.
Mr. Speaker, from the Committee on Finance, Taxation, Commerce, and Economic Development, I also move the appointment of Mr. Rufo J. Lohan to serve as the member of the Guam Economic Development and Commerce Authority Board of Directors be placed in the third reading file with a recommendation to do confirm.
And there's no objection, so moved. So we go back to motion? Senator Lujan? Or Senator Tenorio?
Speaker, a motion to proceed back to motions.
If there's no objection to move back into motions, so ordered. Senator Tenorio?
Mr. Speaker, I move that Bill number 184, a bill to enact a new Section 847 to Title I Guam Code annotated to name the Legislative Session Hall as the Antonio R. Pinco Legislative Session Hall be placed on the second reading. And, I'm sorry?
Oh, Senator, it's already in the agenda. Senator Lujan? That is already, in the, my apologies, that's already in the agenda.
Okay.
Senator Tenorio, back to...
I've taken my cues from the good members of the legislature. Thank you. So I assume we're back now in second reading.
We're back into the, again, we've dispensed with the legislative concurrence.
All right.
We're in the consent calendar.
Okay. Are there any other matters, or are we now in second reading?
And if there's no other matters on consent calendar, Senator Tenorio, we are now in the second reading file.
Thank you, Mr. Speaker. I appreciate it. On my prior motion, we'll remove it now that we're in the second reading. The motion is to place Bill number 119 EC, an act to amend Section 50.54 and 50.58 of Chapter 50 of 8 GCA, and relative to allowing the indictments of unnamed persons whose identities are established by DNA evidence in the third reading. I'd like to speak briefly on the motion.
On bill number 119 EC, Senator Tenorio, you recognize?
Thank you. Mr. Speaker, the motion is to allow this bill to proceed down for hopefully the support that I request at this time from the fellow members of the floor, to allow for our criminal justice system to indict individuals whose names and identities are unknown, but whose DNA evidence has been established by scientific method, which is well known throughout the developed world. The DNA marker of an individual is so unique, it's even better than almost any form of identification. The DNA marker, which has been tested, tried, and true, has allowed many individuals who have been heretofore placed in the criminal justice system for many, many years of their lives. And it's ultimately proven that they were not the person who committed very heinous crimes within our community. And those crimes, of course, being ranging from rape and homicide and other matters. And the same evidence which has allowed individuals to find freedom where they were indeed innocent has also proven that there are people within our community who clearly, without a shadow of a doubt, have convicted the same kind of crimes. This piece of legislation would allow for our criminal justice system, specifically the judiciary, through a grand jury indictment, to indict a John or Jane Doe based on that same DNA marker, that same DNA evidence, which the criminal justice system and our scientific community has been able to offer as one of the best ways to identify a person. And it will allow for, let's say that we had a serial rapist that comes through our territory. We know that we've had serial murderers that have come through our territory, and they've committed crimes, and they've ultimately been convicted here. But let's say we have a serial rapist that comes to our island, and he has eluded the police. He's been able to go within our midst and our presence and be undetected, but is the same animal that has been preying on our community. And then ultimately, the only way we have to identify him is that same DNA marker. If we are able to indict him on a fictitious name indictment, which is called for within the legislation, then we could, in fact, have the toll on time stopped. We could indict him from a grand jury, and the grand jury, the people of Guam, these individuals who are asked to rule on evidence and to make a determination of a true bill, whether or not there's sufficient evidence to bring an indictment against an individual. Now, if we don't know his name is Ray Tenorio or Eddie Calvo or Jesse Lohan or any other person within our community, but we know that his DNA marker is established without a shadow of a doubt, should we not be able to indict him and stop the toll on time? Because we all know that there is a 3-year statute of limitations on most felonies, and of course, except for murder, that's the only one that allows for a lifetime indictment. But this will allow for people who have been violated in the most heinous ways within our community to truly see justice at the point in the future that we actually find the person whose DNA matches his true name, and we know that many people actually change their identity. So this will allow to the indictment of the DNA marker and his name or her name, Jane or John Doe, based on the scientifically proven evidence that will establish clearly who the person is who has perpetrated this crime within our community. Mr. Speaker, I have to say that I think this is probably, no, I think it is, I believe it is progressive legislation that allows for our jurisdiction, this island of 150 some odd thousand people, to be able to actually go after people who have done something wrong but go undetected by their name or their social security number or other forms of identification, but in fact allow for the indictment of that person themselves. So I ask my colleagues to please look at this legislation and please support it, because we do need to find these people within our community that are in fact violating our citizens. And granted, the greater majority of the people are identified by some means, but there are cases where we do not know who they are. And this will permit our system to identify them in a grand jury indictment and toll the time and bring them to justice at some stage in the future. Just must say, Mr. Speaker.
Thank you very much, Senator Tenorio. On Bill number 119EC, the motion to place in the third reading, Senator Palacios.
Thank you, Mr. Chairman. Mr. Chairman, I rise in support of Bill 119 also. I believe when an indictment is handed down, it's more so to the person than to the name that the person carries. When criminal justice is based on DNA, DNA is more to the person than the name that he carries with him. And I believe that the justice system should not be stifled or delayed simply because we do not know the affirmative name of an individual. DNA doesn't change. The name of a person does change, and I believe that this bill allows us to utilize the technology to enhance the justice systems. I support this bill, Mr. Chairman. Thank you.
Okay, thank you very much, Senator Palacios. On Bill number 119EC, Senator Pangilinan.
Thank you very much, Mr. Speaker. Speaker, at first review of this, I don't see too many problems with this issue, but some of the statements that were made, I just kind of want to get a better satisfaction of the basis for some of the statements, and if the author would yield to a question on the matter.
Please state
And
the question, Senator Pangilinan.
The question is, the author says that if you indict someone, you don't know who they are, but you're able to get an DNA identification, that the statute of limitations don't run. And I'm just not familiar with the authority and legal framework for that statement. Is that under what authority is that, because you can indict anybody as a John Doe, basically, unknown is what you mean. Some other people have yet to be identified is the John Doe designation. As a matter of fact, that's what this does. It says identify them through a DNA, but call them John Doe. Well, when you go to indict somebody on a John Doe, you basically say a person we know who was involved in this, but as yet unidentified. So, is there really, in fact, no authority for the saying that the difference is that if you say John Doe DNA number 9 in case so-and-so, that in fact there is no statute of limitations then, and I'm just not familiar with that idea.
Would the author of the bill please, would you care to yield to the question?
Sure.
Senator Tenorio.
Mr. Speaker, thank you. I appreciate the question from the gentleman. My understanding of the system, and granted I don't have a JD after a name, and unfortunately we have a couple people within the hall that do, may be able to give more credence to this and expound on it. But my understanding is that if an individual commits a crime within a certain time frame, if he's not brought to bear for that crime so many years after the fact, the statute of limitations is run. The Chief Prosecutor, Mr. Denko, Phil Tadenko, from the Office of the Attorney General, basically alluded to the particular concern of the crimes of criminal sexual conduct, where statute of limitations exists for these crimes to be prosecuted. And the bill number 119EC, as he wrote, is an important step toward allowing law enforcement the adequate time and opportunity to use forensic DNA testing to achieve justice for victims and defendants alike. My understanding is that there is only a limited amount of time after a crime has been perpetrated for an individual to be brought to justice, and in the absence of an indictment from a grand jury, that time basically tolls when the indictment does occur. So again, I'll defer to those who have those initials after the name with the JD and who have vast more knowledge on this, but that's my understanding of the system as we have it.
Senator Pangilinan, does that answer your question?
No, and it doesn't also provide the basis for, well, he says he's not going to make the statement because he's not a JD. He made the statement, and now he's saying, don't listen to me, listen to the JD. And I agree, but, I just want to, I guess, understand, because my understanding is that you can indict somebody as a John Doe now. And if you collect DNA testing, I don't understand why you need the special designation of being designated John Doe DNA rather than just John Doe. So it may be a case of no harm, no foul, and I just wanted to fully comprehend the shortcomings of the current rules and regulations for prosecution, in addition to the laws that govern those rules and regulations, and the evidence and so forth that are the basis for an indictment. And I need to remind, I guess, the good chair of the committee that when he says we bring people to justice, justice doesn't begin with indictment. Justice ends with the case and the jury making the decision, or the judge in this case. So to just say that because we can indict somebody, we're bringing somebody to justice. We have, as he so rightly points out, we have so many instances now where somebody said we brought somebody to justice only to find out through DNA that it has been a greater injustice by bringing him to justice, because DNA has proven that the individual was not responsible for the crime. So to kind of say we can now bring people to justice because we can indict them, I think is half the, it's the perspective of, indictment doesn't equal justice. I think the complete process of the investigation, the indictment, the trial, the verdict, and then in cases that we find, even years later, as we say, the additional evidence that comes forth may reverse what we thought was justice, and we now know to be injustice. So I only want to ensure that, I don't think this is going to be a problem, because if we collect evidence at the beginning on DNA, then we have the opportunity to ensure that anything that comes, you can go back and compare to that person that was at the beginning. And it may not be after he's served 30 years, as we find so many times happening in our judicial system by these individuals who think that let's just indict everybody and then we'll figure it out later. I think we need to concentrate on providing the resources at the beginning of this process, proper training at the Attorney General's office, proper training at the police department, the ability to collect this. There's federal law right now that requires each individual that's been indicted on certain crimes to provide a DNA sample, so that you have it as a record, and you provide that so that when you find evidence at some other site for some other crime, you go back, and this might, I see, this might be somebody perking up, oh, maybe this is a bill we can introduce here. But there are requirements now in certain instances where everybody that's either been arrested or indicted provide a DNA sample. And that DNA sample is, of course, stored. And that allows the criminal justice system to match it with DNA samples collected at other crime scenes and go back and identify that. There's all these issues, though, that come into play with regards to privacy and with individuals and so forth. But, you know, there are very, very good cases to be made, for example, of why this can help at a later date. So in that respect, you know, the unintended consequences of this is that we may then have DNA samples of individuals that have been out there, found at the crime scene. We keep a log of it and so forth. And every time you find a crime scene in which you don't identify the individual right away, but you can find DNA sample from evidence at that site, you run it through your database, and then you can find that such and such individual was at that crime scene and so forth. So it may help solve crimes in the beginning, not for the very purpose that we have here, but for that additional purpose of collecting this information. And like I said, I'm just not sure that we need a law like this in order to indict somebody based upon being a John Doe and so forth. But if it's no harm, no foul, then I guess we're going to do okay. Thank you, Mr. Speaker.
Okay, thank you very much, Senator Pangilinan. If there are no other speakers on Bill 119EC, Senator Tenorio, would you like to close on 119EC? Senator Tenorio.
Thank you very much, Mr. Speaker. Mr. Speaker, I appreciate the comments from my colleagues on the bill, and I do understand there are limitations, clearly. Maybe it was a reach to say that there is no limitation. What I am saying then in my bill here is to give the criminal justice system more time to be able to go after an individual who heretofore has not been identified, but can be indicted by virtue of this change in the statute. And this bill will allow for the individual to, in fact, come before justice. Now, if justice is served, of course, is ultimately a very objective and subjective issue. I would hope that people who commit this kind of crime and who are indicted under the system will, in fact, be brought to justice and serve their sentence for the community. I believe this statute will be progressive insofar as allowing for our system to acknowledge not only the DNA evidence, but also use it as a basis to indict individuals who are not known by their true names, who are not known by their social security number, but are known by the evidence which is presented before a grand jury, a jury of the people of Guam, who to their satisfaction may be indicted and referenced by virtue of that scientific fact. So I appreciate the comments from my colleagues, and I do ask them to support this bill because I think it will do our criminal justice system a good shake and it'll make our system better than it already is. Thank you.
Okay, on the motion to place Bill 119EC in the third reading, we are now, yeah, but the final speaker has spoken on, I'm sorry, so if there's no objection to the placing of Bill 119EC in the third reading, no objection, so ordered. Bill 123, Senator Tenorio.
Thank you, Mr. Speaker. Mr. Speaker, I move that Bill number 123EC be placed in third reading. I'd like to speak briefly on it.
Senator Tenorio, please.
Thank you. Mr. Speaker, this legislation, if enacted, will give, I think, greater life to not just the criminal justice system in trying to achieve its goals with respect to DUI offenders, but also give and retain life. And what I mean by that is that we have people within our community who go out and get drunk and ultimately are convicted of that offense, and sometimes they go out and get a repeat offense. This legislation will allow for, again, technological advances made in the use of vehicles and the determination of blood or breath alcohol content to be used as a basis for operating a vehicle. Scenario: a gentleman is convicted and he is sentenced, and this is an option, not a mandate, and the payment for the device is mandated by virtue of the defendant. The device is installed in his vehicle and meets the satisfaction of the Department of Revenue and Taxation, which is again drawn out in the bill. and then he blows into the device, and the device determines that his blood alcohol content is too high for him to be driving. The vehicle doesn't start. Now, there's also a system here, well, what happens if somebody blows into the device and allows for the vehicle to be operated, who happens to be another passenger in the vehicle? Well, there's offense against that individual as well for circumventing what the intent of the law is. And the intent of the law is to allow for an individual who's gainfully employed, who needs to pick up his children after school or do other things in the normal course of life to be able to do so, but not do it under the influence of alcohol. So the device basically is basically a tube and a device and a stem that goes up and is within his reach, and he will be able to blow into that tube, and then the computer system within the device will ignite, basically allow for the ignition of the vehicle. In the absence of a breath specimen, then the vehicle won't start. And we're hoping by virtue of this, although it's not here on Guam now, this device is not, and I'm not affiliated with any company who's interested in bringing it in. I just think that this is another example of what I think is an opportunity for our criminal justice system to use other technologies that will keep our people safe. Because if we can keep one person from not going out there and getting to an accident, repeating his DUI for which he was already convicted and the basis for which this instrument was installed, then we can keep people alive. We can keep people and their lives intact. And I think that this will help a lot of our community to feel that hopefully there's another alternative to just putting somebody in their home and saying you can't drive. But you can drive if the device is in your vehicle. And of course, you know, there's no way to make it perfect. There's no way to make a perfect system. There's always going to be some guy who goes out there and he's going to break the law repeatedly, and he's going to go and drink and drive again after he's already been convicted. But I think this will give those people who have already been convicted of DUI offense and the judge who judges over them in our judiciary an opportunity to impose the installation of an ignition interlock device, which will hopefully keep him or her from driving drunk again. So I ask my colleagues again to support this and to help our criminal justice system and law enforcement, as well as everybody else in the community, by preventing someone else from getting drunk and driving all over again after a conviction. Thank you very much, Mr. Speaker.
Thank you very much, Senator Tenorio. On the motion to place Bill 123 EC into third reading, Senator Pangilinan.
Thank you very much, Mr. Speaker. Mr. Speaker, I don't have any objection to the bill. I'm just wondering if we could work it out so that, you know, if the intent here is that we have an individual, for example, who's got caught driving drunk, and, you know, he's not a habitual abuser and so forth, but I wanted to kind of just think about and provide some food for thought maybe about relationship to the confiscation of the vehicle and so forth. So perhaps if the person agrees to the installation of this, then the vehicle shall not be confiscated or shall not be forfeited and so forth, because the intent of getting away with driving drunk is that you don't hurt anybody. And if we now have a system in place that will not allow you to hurt anybody by using your own vehicle, of course you can always go borrow somebody else's car who doesn't have one and drive, but at least we're making it more difficult. At least we're making it more difficult for the person who has a history of the abuse of the driving privilege by circumventing or contradicting the law with regards to impaired driving by influence of alcohol or other drugs. And the other thing is what happens to, I guess, other drugs, other influences, but that's something that we probably don't have a device to measure at this point. But if the device exists for alcohol, then we should move forward with that there. But I just wanted to bring up the idea of the, it really is a hardship for some individuals who made a mistake, realize they made a mistake, are paying the price for making that mistake, but then get their cars taken away or their cars confiscated, and they can't drive to work, as the good chairman said. And if you have this device, maybe we should think about in the future for next a bill that would allow then the individual to have access to his vehicle and not forfeit his vehicle and so forth. So that was the only food for thought. But I think that this, once it comes to Guam, because as we mentioned, I think it's not available on Guam now, and I just want to make sure that it's not overly restrictive in terms of there may be other ways to restrict access to the vehicle with regards to the ability to operate that vehicle if you are drunk, and maybe it shouldn't be limited to just the ignition device, because that's a little bit more complicated. Maybe it should be that there should be a device on just the locking of the steering wheel, and it may be easier to put in a device that you're not able to unlock the steering wheel through a system if you breathe into a breath analyzer and so forth. But I just hope that the fact that we're limiting it to just ignition and restricting it to that if some other new technology comes along, is easier to implement and so forth, that we have to come back again and amend the law, because we're not authorizing things that restrict the operation of vehicle other by restricting ignition. So the concept's good. I think it'll help save lives once it gets to Guam, but there may be other devices out there that may not be connected specifically to ignition. I think we need to research that also. Thank you.
Okay, thank you very much, Senator Pangilinan, on the motion to place Bill 123 EC in the third reading. If there's no other comments, Senator Tenori, no objection to the placement of Bill 123 in EC? So ordered. Bill number 111 EC, Senator Lujan.
Thank you, and good afternoon, Mr. Speaker. Speaker, I move to place Bill 111 on third reading, and I would like an opportunity to speak on the bill.
Please continue, Senator Lujan, on Bill 123 EC.
Thank you, Mr. Speaker. Bill 111, Mr. Speaker, extends the Freedom of Information Act to allow public access to qualifications of persons applying for advertised government jobs. Mr. Speaker, if you allow me, the bill is pretty short and self-explanatory, but I'll go into the different areas of this short bill. Basically, it adds an act to add new paragraph F to subsection 10103 to Title 5, Guam Code Annotated, relative to extending the right of inspection of public documents to resumes and applications filed in response to advertised government recruitment. If you go down to line number 10, Mr. Speaker, of the bill, it says applicant resumes and completed standard application forms tendered for consideration to fill advertised government positions are hereby deemed public records. And all information on applicant qualifications shall be made available for public inspection during the period prior to the actual selection. 14, it says personal information normally exempted from disclosure, such as Social Security and telephone numbers, shall be redacted, means removed or blacked out prior to release. Names may be redacted as well when the applicant affirmatively indicates on the form that his current employer may not be contacted. Government recruitment, Mr. Speaker, the process is based on qualifications and merit. But how can the public know that the most qualified people are being recruited to these critical positions, Mr. Speaker? Bill 111 opens the recruitment process to public scrutiny. Each recruitment matters to other applicants who may want a fair chance to get this job, to the agency that needs to get the work that is needed to be done, and to the public that wants better service for what it pays for in taxes and fees. Bill 111 provides clear guidance for individuals, personnel offices, and the media as to what are public documents. All applicants and news reporters can watch the process of job recruitments to tell them how government officials are using their official power. Bill 111 allows timely disclosure of only the information needed to examine their decisions so that an effective challenge can be made if warranted, if one wants to challenge that, Mr. Speaker. That's the American way. Under Bill 111, job applications become public documents. Personal information will remain exempt from disclosure. Only the recruitment process is subject to public scrutiny under this bill, Mr. Speaker. Personal files of government employees will remain off limits. All other exclusions from freedom of information and sunshine laws remain intact under Bill 111. Mr. Speaker, if you remember back earlier this year, Bill 111 was introduced when the public's right to know was blocked. In a recent, again, high-profile job hiring shenanigan that almost went on. This bill does not address that incident, nor do I seek to repeat the name of that individual, Mr. Speaker. But the government must follow recruitment laws. And my proposal to extend and to clarify the Freedom of Information Act makes open government possible, Mr. Speaker. It protects the applicant's privacy while opening to public scrutiny the process of government recruitment. Are we willing, are we filling the positions, government positions, with the most qualified applicants? Are we getting the best service for our tax money? And I hope that the media watchdogs will be very interested in the passage of this bill to help keep us informed, Mr. Speaker, as they continuously seek the different agencies and scrutinize the applications that go into the applicants to these critical agencies. Again, Mr. Speaker, I remember a few months back, even the oversight chair of that particular agency. It was the good now good former colleague of ours here, Mr. Speaker, Speaker Ompinko, who was requesting information as the oversight chair of the agency, and could not be provided with the qualifications of the individual to this particular position. Even he was not given the opportunity to again view the application. Again, Mr. Speaker, this just extends the Freedom of Information Act. It keeps again all personnel information. Just that keeps everything intact that is intact. It just the recruitment process again for that particular position. This person that is applying for that position qualify? Are the qualifications there for this individual to be able to sit in that position? And with that, I encourage my colleagues again, as we continue to deliberate for open government and fairness and equity, and as we continue to go down this road and say, hey, through the merit system and all that, Mr. Speaker, we must be consistent, again, that we get the most qualified individuals to these positions. With that, Mr. Speaker, I ask my colleagues to support Bill 111 and hopefully see its passage. Thank you, Mr. Speaker.
Thank you very much, Senator Toulon. On the motion to place Bill number 111 EC on the third reading, excuse me? We'll have a 1-minute recess. In the third reading, Senator Gutherts, Judy Gutherts, you're recognized. Senator Gutherts.
Thank you, Mr. Chairman and colleagues. My comments are in reference to Bill 111. I noticed, Mr. Chairman, that this bill only had 3 endorsements to pass and 5 to report out only. And I think I know why. The intent of the bill is fine, but I see some problems with the bill, particularly as it relates to professional persons applying for very specialized positions in very competitive fields. And And I'd like to share with you an example. At the University of Guam, the recruitment of professors in very specialized fields is extremely competitive. And if the School of Business and Public Administration is going to hire an accounting professor with a terminal degree at PhD, the University of Guam is going to be competing with all of the major universities around the country. And those applicants who may be applying for such a position from prestigious universities in U.S. mainland may want to keep privacy during the application process so as not to prejudice their current circumstances at the institutions in which they are presently employed. I dare say we may also encounter the same situation for attorneys, for nursing faculty, and for other specialized academic areas that are in great demand, such as business, economics, so forth and so on. So although I understand the intent of this, I also wish to express concerns with my colleagues that are reflected in the committee report. That recruiting highly skilled individuals to our community, even within our community now, is becoming very difficult at times. And many of them would like to remain anonymous in the application process until the point of selection, in order to protect their careers and their current professional linkages and affiliations. I believe, Mr. Chairman, that we need to work on this bill a little bit more in order to ensure that those individuals that may fall within such a circumstance will not be discouraged from responding to recruitment initiatives by various entities within our government because their anonymity will be compromised. Until we can find a way to satisfy that concern, I think we should do a little more work on this bill. Thank you very much.
Okay, thank you very much, Senator Guthertz. On Bill number 11EC, the motion to place in the third reading, Senator Shimizu.
Thank you, Mr. Speaker. I echo the sentiments of the previous senators, the Honorable Senator Judy Guthertz. For the record, I'm going to the committee report. The keeper of personnel records within the line agencies is the Department of Administration. And the Department of Administration did an analysis on the potential adverse impact on the bill as written. Now, the intent of the bill is very honorable. But as we all know, the road to heaven is filled with good intention. It's really, some of the structural paths that we take. And I want to commend Senator Lohan, has always tried to champion the right of the public to know. But at the same time, this bill, upon which we're talking in terms of applicants, are also members of the public. And members of the public who are coming forth and applying for specific positions there is no dastardly or hidden agenda on the part of any applicant that may say, look, I am putting myself forward, but this is until such time that I am selected. I would like the integrity of the application process be upheld at the strictest of confidentiality, especially if the person did not succeed in his quest for a position, whatever the position may be. And during that process, it's been disclosed of the person applying, did not get selected. That might, again, even after the fact, create an adverse reaction to the person's career. I encourage my colleagues to read the Director of Administration's testimony, the gatekeeper of EEO, Equal Employment Opportunity Laws, Human Resources Rules and Regulations. She enumerated, Director Lou Perez, and I'm sure that this was put together by also her professional staff. And she enumerated 10 good reasons why the bill as written should not go forward. I do understand the sense of public scrutiny, public transparency, but there's opportunities for those to occur without having such a rippling effect, a chilling effect on individuals who may want to offer their highly professional technical service to us, but might be discouraged because of this. That when they put it in and they say, how would I be assured that the integrity of my application is protected? There is always safeguards. The books are filled with many safeguards right now. When people apply, even after they're selected in the classified system, there's a probationary period. But even after they've been selected, civil service can conduct a post-audit on that particular hiring to ensure the public that indeed the integrity of the selection process meets the letter of the law, the intent of the law, and the spirit of the law. Now, we in the legislature, just in the past few months that I've been here, I have seen some of the frustrations of my colleagues when we try to get information and they're withheld in the guise of protecting the individual's privacy and so forth. And they have to resort to the Freedom of Information Act. They have to resort to subpoenas to be able to get those information. But you know, maybe this bill, while honorable in its intent, may need to be reworked again at the committee level, because I even noted that the committee chairman only voted to report out only, with no strong indication as the chairman that whether he supports this or doesn't support this bill. Mr. Chairman, I don't know what will be the process here, because I don't want this bill either to be killed or not passed, because it does have the potential. It needs to be worked on, because even major portions of the committee were just saying, just report it out. So, Mr. Chairman, I hope by the end of the author having the last word on this, I will reserve my vote on that, but I would hope that we don't throw the baby out also with the bath water, but we need to be able to have that Solomon decision that sometimes when the cure is sometimes worse than the cause. And thank you, Mr. Speaker. And again, I want to commend the good author, Senator Lahan, for trying to pave the way to come up with some sense of balance here. Thank you.
Thank you very much, Senator Shimizu. On the motion to place Bill 11EC in the third reading, Senator Wonpat, you're recognized.
Thank you, Mr. Chairman. Actually, I need Mr. Speaker, I need somebody to lower this down for me. One second, because it's taller than I.
That microphone has been hitting your forehead all day. Senator Wonpat.
I was trying to speak.
No wonder why I couldn't hear you.
Thank you. Thank you, Mr. Speaker. That's better now. Can you hear me?
Loud and clear.
Thank you, Mr. Speaker, again. Mr. Speaker, I've listened intently to the concerns of our colleagues here, and I have the same concerns as well. And normally what I would do, and I'm sure my colleagues have done the exact same thing, is that, and in this particular time, is that when we don't have all the facts about a bill, if we've not attended a public hearing, then we definitely would review the committee reports. And there are several concerns that were brought up. As a matter of fact, I'm looking at it right now, and there's approximately 10 issues that came out basically from the director from Department of Administration, and that department is primarily tasked with submitting requests for applicants for a certain position, maybe the creation of new positions since they've just inherited most of the staff from civil service, and also to be able to review resumes and applications, evaluate them, and then put them out, basically saying if they are qualified or not, and then we'll start to set up interviews and training. And there are many valid concerns that were brought up that honestly I've not seen reflected on the bill, because I was looking to see if there was, if the bill was actually amended, and I saw the very first bill, and then I saw what was attached to the committee findings, and it's the exact same thing. So I'm not, real comfortable, Mr. Speaker, when many of these concerns have not been addressed in the bill. I would like to say, however, that the author is really amenable and is willing to work with our colleagues in terms of making some of the amendments and answering our concerns. But and one concern, of course, that many of us feel is that when you're addressing classified positions, they are already protected and governed by the merit system. So I don't think it's necessary to actually have to say that we want to subject these applicants to the same type of scrutiny by a different group altogether when they've gone through the merit system. And I know that a compromise was being worked out basically to only say that these will be positions normally that are unclassified, those we always say that are political hirees, maybe individuals also that boards and commissions would hire, in the hopes that we're not going to harm some of the professionals who, as my colleagues have mentioned, would probably be very hesitant in applying. And that I know it was being discussed, and they would like to work on making some of the changes, but there's still other questions, like I said, that are and there are 10 of them that we still have not really discussed thoroughly, and I hate to be the ones to say that, that I'm definitely not going to be in favor of this, because it does, there's some good things about it. I'd just like to be able to have an opportunity to work a little bit more on it, and I don't know whether this might be the appropriate time, Mr. Speaker, but I surely don't want to take up more time in asking for a recess, so we can do that because there are 10 items. And I know because we are discussing it, and this might not be procedurally right to say that, to put it at the bottom of the file, you know, the second reading file, so that then we can still work on it and bring it up again. I surely don't want to send it back to committee because then, you know, it would die. So I'm looking to your guidance, basically, you know, to make the proper, you see, motion, so that then we'll be able to continue to work with the author of this bill.
Yeah, I will. Thank you very much, Senator Wampat. I will note that before the author of the bill left the floor, he did make certain motions to me that upon his having the final say at the mic, that he was going to move in a certain direction, and I think he was going to ask for a recess.
Okay, so can I go and then request for a recess at least for now until we know where it is?
I'll agree to that. Let's have a 5-minute recess, and so we can deliberate in this issue and try to find a common
okay,
solution.
thank you, Mr. Speaker.
5-minute recess. On Bill 111EC.
Thank you, Mr. Speaker. Mr. Speaker, I'd like to thank you, of course, for the short recess and
The short 5-minute recess, yes.
and the opportunity, of course, to work with the author of the bill. And I understand that he has an amendment that he would like to proffer, I guess, after I close this afternoon. So thank you.
Okay, thank you very much, Senator Wampat. Then on Bill 111EC, if there are no other comments, I'll allow the author of the bill for the final closing statement, as well as, Senator Shimizu on Bill number 111EC.
Yeah. Mr. Speaker, what you just said earlier to allow the Speaker just to close, but this is there an amendment that you're going to? Yes. So he's not closing it.
Oh, yeah.
Just for
Sure.
point of information. So he has to proctor first the amendment, but we just don't close it. Thank you.
Yes, thank you for the clarification, Senator Shimizu. Senator Lujan.
Thank you, Mr. Speaker. Mr. Speaker, I'd like to offer up an amendment, and pretty much working with both sides of the aisles and the concerns brought forth by colleagues on both Democrat and Republicans in regards to concerns in the recruitment process and all that. So in addressing that, working again in harmony with both sides of the aisle, we came up with this amendment that has been passed out to every member of this body, and again addresses the concerns that were brought forth and stated on the floor, Mr. Speaker. And with that, again, I'll let the amendment speak for itself in regards to that. Again, the objections brought forth are addressed in this amendment, Mr. Speaker. And I'm substituting Section 1 to this
Okay.
amendment, Mr. Speaker.
Okay, thank you very much, Senator Lujan. So Senator Lujan has proffered an amendment. Section 1 of Bill 111 is amended as follows, and he's substituting it with Section 1. New paragraph F is added, 10-103 of Title 5 Guam Code, annotated to read. And if there's Senator Blas on the Senator Jesse Lujan amendment.
Thank you, Mr. Speaker. Mr. Speaker, I do have a question for the author of the amendment, if you can yield to the question.
If you could please state the question, Senator Blas.
The question basically, well, actually, it's a little bit of a confusing point here, sir. With regards to government positions, and I'm a little confused here whether this amendment proposes that this is just going to be for positions advertised in unclassified service?
Will the senator yield to the question? Senator Lujan.
Unclassified, not those under the merit system.
With that, Mr. Speaker, just based on experience, there's a little bit of concern here that most times these positions aren't advertised. These are, and you make reference here that applicant resumes and completed standard application forms tendered for consideration to fill advertised government positions are hereby deemed public records.
You know, I can hardly hear.
For the most part, a lot of these unclassified positions aren't advertised.
Yeah.
Yeah. Just a point of concern.
Okay. Thank you. Thank you very much, Senator. If there are any other comments or questions on that, then if not, on the Lujan amendment, Senator Tenorio.
Yeah. Mr. Speaker, you know, this is, just to be clear, as per our conversation with amongst my colleagues, that this was intended to try to resolve some of the concerns of the members on the floor. I'd like to make it perfectly clear that the gentleman's amendment is going in that direction, but hasn't quite made that final leap to make it clear this is only to those individuals that are not subjected to the merit process. And for that, I'd like to insert those exact terms on the fourth line after the word positions, where it says whether to fill positions in the unclassified service. So I'm going to put after the word positions, not subject to the merit process, and then continue the sentence. So it would now read, for qualified public servants, whether to fill positions not subject to the merit process in the unclassified service or executive positions. Now, I'm open to suggestion on how to improve this further, but the clarity needs to be that these are for individuals that are not subjected to the merit process, and only to those who are in the unclassified and executive positions.
Okay. Thank you very much, Senator Tenorio. So Senator Tenorio is proffering an amendment to the amendment on line 4 after the whether to fill positions and this is not subject to the merit process, and then continuing in the unclassified service. So in the merit process, correct?
Correct.
On the Tenorio amendment, if there's no comment on or questions on the Tenorio amendment, if there's no objection, okay, amendment to the amendment carries. On the main amendment as amended, Senator Shimizu?
I'd like to speak to this. If maybe we can just have...
Gentlemen, if we can have some order here. We have a senator on the floor. Senator Shimizu, please, continue.
Yeah, thank you, gentlemen. I'm trying to read this with a certain amount of, from a layman's point of view, because once we enact this thing, I don't want to be entangled in if it's not clear. It's really not clear in my mind yet, even with my good colleague Ray Tenorio's amendment. It's not clear in my mind that we are still, like I said, putting a chilling effect on applicants, whether they're in the unclassified or the classified. You know, I look at this in terms of, let me just read it, whether to fill positions, and then Senator Tenorio, not subject to the merit system or classified, in the unclassified service or executive position for which educational, technical, and/or professional experiences are specified. And then it says, and upon appointment directly or indirectly by the governor or directly by a board or commission, period. For me and I, if you know English, is not clear. We have run-on sentence, and where sigat tumotsi, keep putting, what are we saying here? You know? I understand that the main intent is to be able to have a transparency, protect the integrity of equal employment opportunity. And within that area, we're now trying to say that the classified employees shall not be subjected to this. However, it still is not clear in my mind that when it goes to in the unclassified service or executive position for which the educational, technical, and/or professional qualification are specified and upon appointment and directly or indirectly by the government and so forth. I'm trying to figure out what does that clause say. What is it? It needs more clarity, at least for me. I don't know about some of the other folks here that may have a better understanding if you know English. But if we go further, it says applicant's resume and completed standard application forms tendered for consideration to fill advertised government positions are hereby deemed public records. And all information on the applicant's qualifications shall be made available for public inspection during the period of the actual selection. During the period of the actual selection. Now it goes on to try to protect personal information normally exempted from disclosure, such as Social Security, telephone numbers, shall be redacted prior to release. Names may be redacted. He didn't say that they shall be redacted. Somebody says, well, it only says may, or mother may I. So I say, no, I'm not going to redact it. When the applicant affirmatively indicates on the form that his current employer may not be contacted. A request for inspection or copies of applicant's information shall cause a stay. We're going to stop that process on any further processing towards filling the positions, such as period to end the 2 full working days after requests of documents are made available. One of the things that I looked at as the former hospital administrator, when we're trying to get highly technical, professional people in, this might just have a chilling effect on that. Think about it. When you may need a neurosurgeon that is coming from Mount Sinai, but may want to come out here, but with this thing, that might be too chilling. Because, as I was talking to an alumni from the University of Guam, a very intelligent young man who's watching our deliberation, if you look at this and you redact the names, all I have to do is go look at the last employment of the person. He was the last employed or currently employed at Mount Sinai. And I can say, or City Sinai. I can just call that up and say, do you by any chance, I don't know the name, but here's the background and so forth. This young man said, Senator, all we have to do is just keep, lining the dots. Eventually you'll come out to be Dr. So-and-so. I am just saying that I pride myself in looking at the language so that there will be some clarity and try to meet the intent, the honorable intent of the good author. I'm just not sure that we've met that threshold. I'm not sure we've met the threshold that whereby if we enact this might put a chilling effect. The world is small. People have job resumes out there in monster.com, Jobs USA. We advertise in those professional journals, but there's always going to be a footnote down there. Applicant, beware that under the provisions as we write this, that even when at the end of the process is taken care of, a request for inspection of copies of applicant's information shall cause a stay of any further processing towards filling the position. I tell you, with the highly professional people, with my skills and what I can do, I don't need this kind of such period to end 2 full working days after requested documentations are made available to requesters. And then we can go on and say, well, we can inundate by the number of requester. Requester number 1, requester number 2, requester, and that multiplies, my colleague. A caution, I admire the intent. And this is a reaction A justified reaction, maybe. But it may not be the solution. A justified reaction, maybe on the arrogance of those who say, that snubs the request of duly represented. And then it forces, again, like I mentioned earlier, a adversarial relationship. But by the time we get that done, we lost that applicant. We lost that applicant. I think we need to not only have a 5-minute elongated recess to look at this, but I think that the intent is so honorable that we need to take it back to the surgery room and work it closely with our legal counsel, the attaché, and maybe to really look at it so that there will be some clarity beyond a shadow of a doubt on who and what, and look at what the potential impact might be. So I will make a suggestion that the author reconsider and be given the opportunity to work with the good chair of the committee to work on it and bring it back. I don't want to kill it now, but I don't know how many days of session that we have, but I don't think we've been able to achieve the level of clarity, and maybe we can bring our newly sworn legal counsel to look at that and then maybe come back. But I think we need a little bit more time to understand the chilling effects that this could occur. Thank you, Mr. Speaker.
Yeah. Thank you very much, Senator Shimizu. On the amendment as amended, if there are no other further speakers, Senator Espaldon, on the amendment as amended.
Thank you, Mr. Speaker. Mr. Speaker, I fully appreciate the intent of this bill introduced by Senator Jesse Lujan, and it does go to a certain extent to ensuring transparency and accountability in our government and how we hire. However, the last sentence causes me to pause. I mean, yes, there are, so noted all the arguments put forth by and observations put forth by the previous speakers have been duly noted personally here. But for me, the real one is the one that really bothers me to an extent is the last sentence. A request for inspection or copies of applicant information shall cause a stay on any further processing towards filling the position. Such period to end 2 full working days after requested documents are made available to the requestor. Now, the previous speaker touched upon this last sentence briefly, and I'd like to expound upon that just a little bit more. It won't take a lot of time, but I believe this will have a lot of unintended consequences, because essentially, again, as the previous speaker pointed out, that if there is a very necessary position that needs to be filled, and perhaps one of the candidates, 1 or 2 or 3, or maybe even all the candidates, are not acceptable to certain members for whatever reason, whether it be political, whether it be a personal vendetta or whatnot, it'd be very easy to line up a succession of requests to go in and ask for this, and that would eventually mean that there would be a stay indefinitely if you just keep amounting a request after request after request. Of course, all the requests could be initiated by different personalities and different people, but nonetheless, the stay would be in place. And so the unintended consequence down the road is that no decision will be made on perhaps what could be a very crucial position to fill. And so I have a problem with this aspect of it, in that it actually, even though the intent is good, it may serve to be a real hindrance to actually filling positions that are necessary to get filled. And that's the only comment I'd like to make. It's all about the unintended consequences. As good as the intent of the bill is, there may be some unintended consequences which may be detrimental. That's all I have to say. Thank you, Mr. Speaker.
Thank you very much, Senator Espaldon. Again, on the amendment as amended, if there are no other speakers on the amendment, Senator, you can close on the amendment as amended.
Thank you, Mr. Speaker, and I thank you for, I thank my colleagues for speaking to the amendment, and there were a couple concerns that were brought up in regards to that, and I've got no objections in the last sentence actually being removed, Mr. Speaker, in regards to that, to satisfy some of the concerns of our, in regards to that, I'd like to move to make the amendment. I got two amendments, actually, Mr. Speaker. in
Okay,
regards
so you
to that.
move to make two amendments.
Yes.
The first one is to,
To address the concern, to remove the last sentence, a request for inspection of copies,
okay, so,
and to the end of the sentence.
okay, so on the First Amendment, to remove the last sentence on the amended amendment, if there's no objection, motion carries, amendment carries. On the Second Amendment to the
And
amendment?
the other amendment, actually, Mr. Speaker, is, on the seventh line, the very last word is, it says to fill advertised government positions, just to remove the word advertised.
I'm sorry.
Strike it, just strike.
Where is that again?
It's on the seventh line,
On the seventh line.
the very
1,
last word,
2,
it says
3,
advertise,
6, 7.
is preceded by to fill advertised, just
Oh, in the
to
sixth
strike
line,
out the
1,
word
2, 3.
advertised.
On the sixth line.
Sixth line, I'm sorry.
To remove advertised,
Strike out the word advertised.
strike the word advertise. Okay. And on the Second Amendment, to strike the word advertise, if there's no comment or objection. Okay. Amendment to the amendment carries.
Thank
On the main amendment as amended,
thank you, Mr.
if there is no objection, amendment to the amendment, main amendment as amendment carries. Now, on the main motion to place Bill 111 EC as amended on the third reading, if there's no objection, motion carries. Senator? Okay, there's been a motion to recess until 10 o'clock tomorrow morning.